The status of healthcare coverage for millions of Americans is up in the air. Again. Welcome to Advancing Health, a podcast from the American Hospital Association. I'm Tom Hedderly, senior writer with AHA. The efforts to strike down the landmark Affordable Care Act again returned to the Supreme Court of the United States. In this podcast, AHA General Counsel Melinda Hatton and AHA Outside Counsel Sean Murata, a partner at the Hogan Lovells Law Firm and author of AHA's Friend of the Court brief in the case, discuss their immediate reaction to the November 10th oral arguments in the case of California versus Texas. Let's listen.
Hi, I'm Mindy Hatton. Sean, so now that the oral argument is finally over, I'll ask the question that's on everyone's mind. Who's going to win? Is the Affordable Care Act going to withstand this third attempt to bring it down?
Thanks, Mindy. Everything is hard to tell from oral argument. Oral argument is not always a perfect predictor of how the justices will vote. But if you're a supporter of the Affordable Care Act like AHA is, you come out of oral argument feeling good today. And that's for the simple reason that both the Chief Justice and Justice Kavanaugh, both regarded as part of the court's conservative wing, strongly signaled that they were not on board with the challenger's argument that the entire Affordable Care Act must fall if the court finds that the mandate without a penalty is unconstitutional. When you add their two votes to the predicted votes of Justice Breyer, Justice Kagan, and Justice Sotomayor of the court's liberal wing, that's the 5 votes you need to make a majority. So, although nothing's certain coming out of oral argument, supporters of the ACA should be feeling pretty good right now.
That's good to know. Now, there was a good deal of discussion today about whether the ACA's individual mandate is constitutional, even though the tax penalty that enforces it has been set to 0. What was all that about? And does it matter if the individual mandate is still constitutional?
Sure. So 7 years ago, the court held that the individual mandate was constitutional, not because Congress could command everyone to purchase insurance under its Commerce Clause power, but because the court read the mandate as essentially a tax. It gave people a choice. Either you could buy insurance or you could pay a tax to the U.S. Treasury. So the question today is a tax that's set at $0, which is what Congress did in zeroing out the penalty that backed the mandate, is that still a tax? And if so, or if not, does that mean that the mandate can be supported under the Congress's taxing power anymore? But really, Mindy, it just doesn't matter what the court thinks about this, because as everyone recognizes, there's really no meaningful difference between an individual mandate that doesn't exist and an individual mandate that has no penalty behind it. Because most people do things because there's a penalty for not doing it, such as having to pay money to the Treasury. And all the sources that have looked at this, including the Congressional Budget Office and others, have recognized that there's really no difference between that penaltyless mandate and no mandate at all. So what's really going to come down to is the question of if the mandate is unconstitutional, does the rest of the law have to fall with it?
And certainly there's a lot of discussion about that issue. But before we get to that issue, the Chief Justice really opened the session by asking whether or not the ACA challengers had standing. What was he driving at, and what could that mean for the ultimate result?
Sure. So it's a requirement of federal courts that if you bring a lawsuit, you have to actually be injured by something. You can't just go to file a lawsuit and say that I'm upset about something or I think something's unconstitutional. Instead, you have to show a concrete way that the law is injuring you. And the challengers today really had 3 theories for why they had standing. One, the individual challengers, individual plaintiffs, said that, well, even though there's no penalty, I still have to buy insurance because the law says I have to, and that costs me money, so I'm injured. The problem with that is that U.S. law tells you to do a lot of things. It suggests that maybe you should stand up when the national anthem is played. It suggests that maybe on Arbor Day you should go plant a tree. But no one thinks that those are actual commands that you have to follow or else. So that was part of the conversation today. Their second theory for standing came from the states like Texas, who say that, well, because of the individual mandate, we have to fill out certain paperwork, or more people may sign up for Medicaid. And that's going to cost us money, so we're injured. The discussion today about that is that it's not clear that Texas actually proved any of that through their evidentiary submissions in the lower courts. And in fact, it's not even clear that it makes sense as just a matter of logic. If you have people who didn't sign up for Medicaid back when it would have cost them a $1,000 penalty not to do so, why would they sign up for Medicaid when there's literally no consequences for doing so? And then the third theory of standing was that although the mandate doesn't injure us or cost us money, other parts of the Affordable Care Act do. So that because we argue that the entire law has to follow with the mandate, we have standing because we're worried about these other provisions of the Affordable Care Act. And there was a lot of skepticism about that too, because it's a kind of argument that the court has never adopted before. And because most laws are passed in these large omnibus packages like the Affordable Care Act was, it might suggest that lots of laws are open to this kind of attack or this theory of standing. And so the court was hesitant about finding standing there. But what it could mean for the case is that the court may never reach the merits of the Affordable Care Act. They may just simply say that the mandate as it exists today isn't hurting anyone, so we don't even have the power to hear this case.
Right. So you mentioned it earlier, but really the main issue before the court and the argument I think that many of us thought would ultimately be its savior is if the individual mandate is unconstitutional, whether it can be severed from the rest of the law and the rest of the law remain in effect. What do the justices seem to be thinking about that?
I think it's fair to say there are at least 5 votes on the court to find that even if the mandate is unconstitutional, the rest of the law can be severed from it, such that really the Affordable Care Act is going to look the same today as it does after this case. And that's for the simple reason that, one, Chief Justice Roberts asked questions that he was almost sort of annoyed that the challengers were coming to court and asking the court to invalidate the law when Congress couldn't muster the votes to do so. One of Chief Justice Roberts' hallmarks is deferring to the political branches and keeping the court out of the contentious issues of the day as much as he can. And you could hear a real annoyance in his tone that the court is asking to do the thing that Congress couldn't muster 51 votes to do. And then you had Justice Kavanaugh on the other end of the bench, one of the more junior justices, who said that he simply thinks that the question of severability follows directly from the court's cases. His point seemed to be that Congress knows how to draft laws. It knows how to make a law inseverable if it wants to, and there's a presumption in favor of severability. So when you take those presumptions and you add it to the fact that certainly nobody in Congress thought that they were going to be blowing up the entire act by zeroing out the mandate penalty, there was no reason to think that Congress would have wanted the entire law to be eliminated just because it was zeroing out the penalty. So when you take those 2 votes and you add it to the 3 votes of the justices in the liberal wing, that's the 5 votes you need to uphold the Affordable Care Act. And you never know, other justices might even join them.
Well, speaking of other justices, the newest justice on the court, Justice Amy Coney Barrett, certainly got a lot of questions at her confirmation hearing, trying to probe how she would vote on the Affordable Care Act litigation that they knew was coming. Did we get any clues to how she might come out on this case?
I don't think we did. Justice Barrett asked questions of both sides that were probing of both sides. It could be that she's the deciding vote on whether the challengers have standing or not. And some of her questions were probing the question of standing. But on the merits, I don't think you really got a feeling either way what Justice Barrett thought. And what it suggests is that she's being thoughtful about these issues. And we'll just have to see how she comes out when the opinions come down.
Okay, were there any surprises from the oral argument today? You know, Sean, you've been involved in the various challenges on behalf of the American Hospital Association for a number of years. So it would take a lot to surprise you, but any surprises today?
I think a surprise for people who come at this case just from thinking about liberal votes and conservative votes is how clear the Chief Justice and Justice Kavanaugh were in showing that they really did not believe the challenger's severability theory. I'd say close court watchers knew ahead of time that the Chief Justice and Justice Kavanaugh might be on the side of the Affordable Care Act. If you just think of cases in terms of conservatives and liberals, sometimes you're going to be surprised. And this is one of those cases where their views on the legal doctrine really did not line up with the challenger's views. And what I think you may see is that you're going to end up with a decision that is going to go in favor of the Affordable Care Act, but also do so through votes that are generally thought of as quote unquote conservative.
Great. Okay, so now that the case has been submitted, when can we expect to know the result?
So the only guarantee in the U.S. Supreme Court is that they issue all their opinions by the end of June. So I can at least guarantee it's going to come by the end of June. But this case, unlike some of the other challenges to the Affordable Care Act, was argued earlier in the year, now that we're only in November. So we may see a decision as soon as 3 or 4 months. What it may take some time to figure out is how the court feels about severability, and that may lead to shifting alignments of justices. So it could take them a little bit longer to write all of their opinions, but we will certainly know sooner rather than later how the Affordable Care Act's fate is going to be.
Well, thank you, Sean. We really appreciate all the work that you have done for the American Hospital Association over the years on this issue. We look forward to a decision, and we will be undoubtedly we'll be talking to you again when we get one. So thanks, everyone.
Thanks so much for having me.